Okay, this is Legal and Ethical Issues in Education. It's EDL 702. This is Module 3, Students and Rights and Restrictions. So we'll jump right into Module 3 here. And let's begin. So this is it, Module 3, Student Rights and Restrictions. Last week we talked about freedom of religion. It was found in the First Amendment of the Constitution. And this week we're just going to continue with some First Amendment rights, student rights, those rights, that individual rights. So this week let's look at these. There's really four. There's two big ones, and then there's four in total as part of First Amendment rights that students enjoy. So you can see these. It's freedom of speech, it's freedom of press, freedom for people to assemble, and then to petition the government. You can see those here. So let's start with the First Amendment right of freedom of speech. And you'll see, as we talk about and you read in the reading, that students enjoy some of these First Amendment rights. And so we have to take those seriously, have to take those into consideration. So probably the big landmark case for freedom of speech in schools was the Tinker versus Des Moines case in 1969. And in this case, the issue became, do these two students in the picture here, have a right to wear these armbands in school as a form of protesting the Vietnam War? So the young man, John Tinker, who's 15 years old, and Christopher Eckart were two of the folks that were involved. Mary Beth is John's sister. She's in the picture. But what these students did is they just wore the armbands. Didn't cause any disruption. They just wore these armbands. And so the court decided in a 7-2 decision, so it wasn't close, that the First Amendment applied to public schools. And that was the first time that actually had happened. And that administrators would have to demonstrate that there were valid reasons for interfering with a student's First Amendment rights. So the significance of this particular case, and this has been quoted throughout a lot of different other Supreme Court cases. The opinion stated that neither students or teachers shed their rights at the schoolhouse gate, that the school is responsible for showing that the students' conduct would materially and substantially interfere with the operation of the school. So beginning in the 1970s, then, school administrators had to start worrying about things like a student's constitutional right to free speech. So what does that mean? Can they say anything? I mean, what are the limitations? And the court through the years has talked about some limitations, and that there are some speech that schools have a right to protect. In 1987, there was another landmark free speech case, the Bethel School District number 43 versus Frazier. In April of 1983, Matthew Frazier decided that he was going to deliver a speech at a school assembly in favor of his candidate for student council, and or whatever student council office it was. And in the speech, he used a lot of sexual innuendo. So the school district punished him, and then he, through his parents, he appealed that, and it finally made it to the Supreme Court in 1987. So does the First Amendment protect the student's right to deliver a vulgar or a speech at a school assembly. So what do you think? So the court says no, that the First Amendment doesn't provide that protection. And in fact, the Supreme Court overturns lower court decisions that said that the student had the right to make those speeches. So the significance of this is that schools do have limits. There are places that you as a school administrator, you can regulate the speech of your students, and the there is a limitation. There is a place to go. So what are some freedom of speech issues for you? Well, one of the things I asked you to do is to read a couple of articles in the newspaper about incident that took place last December, not that long ago, in a Pennsylvania high school. Apparently some students were wearing shirts or coats or something that had a Confederate flag on it. And one of the parents of a student complained and said that was interfering with his child's rights, and that his child was having trouble in school. So, is this a free speech issue? How did that go down? And if you read the article, you'll read that the superintendent first quoted the Tinker case, and basically used the exact same verbiage in language and said, look, the students, they don't shed their rights when they walk in the door. So we have to take that into consideration. And subsequently, if you read through both of the articles and looked at it even further, you'll find out that eventually there was a material disruption of the school. And so eventually the school was able to say, look, don't wear that stuff to school again. This photo is actually of two of the students who were protesting the decision and went outside with their little blanket. And you can see the blanket. I mean, it's very evident that they were what they were trying to entail. So is this a free speech issue? Absolutely it is. Does the school have the right to regulate speech? The school does have the right to regulate speech when it becomes a disruption in school. So you just got to be very careful about, just interfering with someone's rights immediately. But if it becomes disruptive, then absolutely that you can regulate that. So the second of the First Amendment rights is freedom of the press. And so, in lots of schools, and especially the secondary level schools, the students have newspapers or they publish newsletters or whatever the case may be. And so you have to take into consideration, when that's the case, they become quasi the press. And so you have to understand your role in that. And so the landmark case dealing with freedom of press in the schools is this case of Hazelwood versus Kuhlmeyer in 1983. And basically it's a case where the high school paper in question is called The Spectrum. It's part of the journalism class at Hazelwood East High School in St. Louis, Missouri, and was completely supported by the school district. So the principal at Hazelwood, he reviewed the paper before it was published, so he had prior review. And so in 1983, there were a couple of stories that he objected to, and he decided he didn't want them published. One story about teenage pregnancy, another story about divorce. So the principal was concerned that although some of the students had been assigned pseudonyms, it still might be possible for some of the other students in the school, to be able to guess their identities. So he felt like it would be problematic. The students in question decided that they felt like that they were being censored and that they had freedom of press, went all the way up through the Supreme Court. And at the Supreme Court level, the Supreme Court says certainly school officials can censor the student newspapers when they can justify that from a educational point of view. Generally, we can't censor them for no reason, but if it interferes with the school, we can censor them. And you can see what the significance of that is, and that again, is allowing the school district to limit the constitutional individual rights guaranteed to them by the First Amendment. So some of the other First Amendment rights that are in the First Amendment, the right of the people to assemble. And so, there are occasions where students and student groups may want to come together in some kind of an assembly, on their own, not one that's put up by the school. As long as that doesn't interfere with the school or interfere with the educational process, I don't think that's going to be an issue. And then the last of the First Amendment rights deals with petitioning the government for redress of grievances. And we're going to talk a little bit about that in the due process because that really kind of overlaps to due process. So, this would be an example of this would students be allowed to address the superintendent or the school board about, a teacher who's been recently terminated or a program that's been eliminated? And I would think that as long as the students didn't disrupt the school, that they would be allowed to have their say. It's really part of our culture to allow folks to have their say. And then it's also ingrained in the due process rights that we'll discuss in the Fourth Amendment and the Fifth Amendment and then the 14th Amendment. So another Bill of Rights amendment that sometimes comes into play in schools, especially at the secondary level schools, is in the Fourth Amendment. And there's a lot that's in the Fourth Amendment, as you can see, but really the part that comes into play and has been litigated is the Fourth Amendment, where it talks about the unreasonable searches and seizures. So the landmark case for the unreasonable searches and seizures is the New Jersey versus TLO case in 1985. And so basically, it is a case that asks the question, can school officials search students? In this case, young lady was caught smoking, and the school searched the young lady's purse, found that she had drug paraphernalia, marijuana, and so she was charged for that illegal conduct and the paraphernalia that was found on her. And so she fought the search and basically said that it violated her Fourth Amendment right against unreasonable searches. So what did the Supreme Court say? Well, again, the Supreme Court, and again, is continuing to allow schools to limit individual rights. The Supreme Court said that, yes, the school can search students, said that there's a legitimate expectation of privacy, but that the school's interest in maintaining order and discipline, that superseded that individual right. So you can see, and we're going to talk about this here in just a second, school officials may properly conduct a search of a student's person if they have reasonable suspicion. So a reasonable suspicion standard, rather than the police officers are required to have probable cause. So reasonable suspicion. And we'll talk a little bit more about that here in in fact, the next slide. So search and seizure. All right, the courts upheld reasonable suspicion searches in these four instances. You can search lockers, you can search classrooms, you can search vehicles, and you can search students if you have reasonable suspicion. So what is reasonable suspicion? Well, basically, it's what a reasonable person, given the same set of circumstances and information, would that person have the same suspicion, if you will, or belief that there's something that's been going on. So if a student came to you and said that Jimmy had illegal drugs in his locker, would that be sufficient to meet the reasonable suspicion standard? Absolutely. A student coming in informing, or a parent or another teacher, those happen a lot, and those become the primary basis for reasonable suspicion. Now, can you just go search anybody at any time? Well, the court says you can't. You can't perform random searches of individuals, but you can, and it's been done, a lot. you can perform random searches of school property. So what's school property? Well, school property is things like lockers, classrooms, parking lots. So those things are school property. And so you can perform random searches of those. You cannot perform random searches of individuals. Okay. Drug and alcohol searching or testing is considered a form of a search, and that's been upheld by the Supreme Court. The Supreme Court also has said that personal media devices are subject to the reasonable suspicion standard. So if you felt, if you'd gotten information that a student was texting threats to another student, then you could search the suspected student's cell phone. So it's important, that you understand this reasonable suspicion standard, but it's also important that all these possibilities be listed in something like a student handbook or code of conduct. And when we talk about here due process here in just a second, you'll see that all of these searches are subject to both procedural and substantive due process. And that's primarily accomplished through your board policies and through your student handbooks and what have you. So let's talk about due process. So remember, due process is the only thing that's actually mentioned twice in the Constitution. In the Fifth Amendment, it says that no person shall be deprived of life, liberty, or property without due process of law. And then in the 14th Amendment, where it says that nor shall any state deprive any person of life, liberty, or property without due process of law. You might also remember that the 14th Amendment includes the Equal Protection Clause. But what we're going to talk about and how it pertains to us, and maybe is the single most important thing that you'll learn in this entire class, is this whole idea of due process and the importance of providing students due process. So the landmark case for the due process issue, it happened in 1975. And in 1975, several students, including Dwight Lopez, were suspended from a high school in Columbus, Ohio for 10 days for destroying school property and disrupting the learning environment. And Ohio's state law allowed the school principal to suspend the students for 10 days or to expel them. So the students were suspended. And it went through the whole process, the whole court hearing process, to the district court, to the appellate courts. And basically, the Supreme Court says that you can't suspend a student, you can't rob them of that property right, of that right to an education, without offering them due process or a hearing. In this case, it was a hearing before the suspension. So the significance of the Goss versus Lopez case is that it extended those Fifth and 14th Amendment protections of due process to schools. And it defined that receiving an education is a property right that's guaranteed by the state. And therefore, because of the 14th Amendment, if it's guaranteed by the state, it's also subject to these constitutional due process provisions. So here's the point. You can't take away a kid's education through any way without having a procedure or a process. And so that's what this whole thing is really about. So your textbook talks about 4 different due process in vocabulary words, for lack of a better term. You have 2 types of due process: the procedural due process, that's the guarantees that the set of steps is going to be followed. It also allows for students, and in fact, this you'll see works with your staff as well, seeks them an opportunity to answer the the allegations and to seek redress for these violations. So procedural due process. An example of procedural due process would be, most of you have in your teachers' handbooks, and probably even in your student handbooks, a way for teachers and or students to appeal a decision through, it's called a grievance policy. So you probably have something like a grievance policy as an example of procedural due process. It's a procedure, it's a process that you follow. The second vocabulary word, the second thing that happens with due process is substantive. And this is this whole idea that students, and again, this will be extended to staff when we talk about teachers here in a couple of weeks, that they can't be subject to arbitrary or capricious acts. So what are arbitrary and capricious? Well, they're just off the top of your head. They are based off of no standard. They are, inconsistent. So it's important in meeting this substantive due process process standard that you as a school principal be consistent and have something written down so that you can follow, you can treat everybody the same way. Your book talks about the vagueness doctrine, and the court has said that students can't be penalized for behavior that they couldn't reasonably understand was prohibited. Therefore, it's very important in your student code of conducts and your discipline management plans that you list that these are the behaviors that you can be and will be punished for. That's the vagueness doctrine. The presumption standard is the presumption that behavior being disciplined is under the authority of the school. You must have a reason for that to be something that you can, that you can punish. For example, in the presumptive standard, and this, by the way, is is being litigated, so this may change. But you have students who are off campus, away from school, are using Facebook or other social media to bully one another back and forth. Is that something that the school has authority over? That's not been determined definitively, and so the presumption standard would be that that's not the area of the school in most cases. So those are the due process vocabulary words, if you will. So what are my practical recommendations? So here they are. Man, you've got to have a student code of conduct and discipline management plan. There has to be something written. These are the things that are prohibited. This is the behavior we don't allow. This is what happens to you if you break the rules. The second thing is you have to be consistent in your enforcement of your school rules. I used to tell, or I still tell my principals, what you do for one, you have to be able and willing to do for everyone. So I can't treat Jenny differently than I treat Sam. They have to be treated the same way. There has to be consistent enforcement of the rules. And so it's important. I mean, that's that substantive due process, is there's consistency. The third thing I would say is that you have to provide students an opportunity to tell their side of the story. And the harsher the consequence, the more formal that opportunity needs to be. So kids need to have the opportunity to tell their side of the story. I've had teachers dragging a kid in by the arm, saying, this kid did X, Y, and Z, and stand there expecting me to punish them, expecting me to, throw the book at them. Well, I've not even heard the kid's side of the story. And the kid's side of the story may not matter. And in fact, most of the time doesn't. But it doesn't mean that I don't give them that opportunity. So I have to give them that opportunity. And the fourth thing I would say is that there needs to be a grievance procedure or a way to appeal a decision. And this goes from the teacher to the principal, or to the vice principal, then the vice principal to the principal to the superintendent, superintendent to the school board. There needs to be an appellate process so that a decision can be appealed up the line. So that's basically the practical advice for due process in schools. So the next Bill of Rights amendment that sometimes comes into play in schools is this one. The Eighth Amendment that prohibits cruel and unusual punishments. At least there are people in the public that feel like that is a protected constitutional right. And the reality is that, the reality is that, and most of the time when you talk about cruel and unusual, what they're talking about is this idea of corporal punishment. So the reality is that the Supreme Court has said that corporal punishment is an acceptable form of punishment in schools. And in fact, in their same decision where they said that, it's Ingram versus Wright in 1977, in that exact same decision, the court said the Eighth Amendment, therefore the amendment we just talked about, cruel and unusual punishment, the Eighth Amendment does not apply to the administration of discipline through corporal punishment to public school teachers and administrators. So there's the big deal. Corporal punishment is allowable according to the Eighth Amendment. Now, the court also said it needs to be reasonable and it needs to be administered by someone who's not motivated to inflict harm, somebody who's mad, if you will. So a good faith. It needs to be have a good faith standard. So we talk about student discipline as school principals. You need to understand it's allowable. Now, I will tell you that I don't advise it. I have administered corporal punishment as a school principal, and I have decided that I wouldn't administer. I mean, from a policy standpoint, we've done away with corporal punishment as a school principal. I'm just saying you open up too many liabilities as a school principal when you use corporal punishment, but you may be at a school district where that is a part of the expectation. Just know that you can administer corporal punishment as long as it's reasonable and it's done in a good faith standard. And then your school may have additional guidelines, which is fine. Let me talk to you real quick about suspension. The court says, as you read in the Goss v. Lopez, the court says that you can suspend a student, but you have to provide them substantive and procedural due process. So that basically means you need to provide the student notice of suspension. You need to provide for an informal hearing. It doesn't have to be anything real formal. In fact, my suspension hearings typically were meetings with the student. You have to allow the student's parent to be present, and then you have to hear all sides of the issue before making the decision. And that's basically it. You have provided now due process. Expulsion is a little different ball of wax. Expulsion is a little more formal because, again, you are taking away a kid's right to go to school. They can't go to school anymore when you expel them. So it is an extremely serious event and needs to be taken as such. So several things that need to happen. First of all, it needs to be formalized. So expulsions need to be formal. There needs to be something written in the school's discipline management plan and code of conduct that lists any actions or behaviors that may result in expulsion. This meets the vagueness doctrine, and it also provides the beginning of the procedural due process that you need. You need to provide written charges, so you need to provide a formal notice of the charges, and you need to have a formal hearing. So what all is involved in a formal hearing? Well, a formal hearing involves a impartial judge, someone who's going to judge the recommendation for expulsion based off of the facts, based off of the evidence. You have to have evidence, and you have to allow the student who's being expelled and their parents to be represented. They can be represented by attorneys, they can be represented by their parents, they can be represented by themselves, but they have to be able to be represented. And in that, they have to then be allowed the opportunity to inspect or evaluate the evidence against them. They have the right, the student has the right to call witnesses. and they have a right to cross-examine the school's witnesses. And then there has to be an appeal process. Does it sound like a court? Does it sound like we're talking about a court decision? I mean, it is. That's basically what we're talking about. We're talking about a trial. And so while the hearing process doesn't have to be quite as, you don't have to hire a stenographer to come in, you don't have to hire a prosecutor or any of those kinds of things, but you do need to have all these things written down that are the rights of the student, so that you are providing to the student this due process procedure. And if it were to be appealed past, then any court in the land would say that their due process rights have been granted. So expulsion is a big deal. And then your book talks about this a little bit. You guys need to understand that students can be disciplined for off-campus behavior when off-campus behavior negatively impacts the school. So it's important that that behavior be listed in your code of conduct. And it's important that that information, that the students have been given the information of the behavior that's been prohibited. So that's it. I mean, and this is it's a big chapter. This will be a chapter, especially the due process parts of it, that you will, that you will deal with. You will deal with issues that are in this particular area in student rights. So here's the last thoughts, guys. The court says students don't shed their individual rights when they enter the schools, but the court's also said consistently that school administrators are responsible for not just respecting those individual rights of each student, but also ensuring the education of all students in a safe and orderly manner. And so if you just keep that in mind, I'm going to respect the individual rights of the student, but I'm also going to make sure that we are, we're having school and we're having it in a safe environment. So that's it. Until next week, we'll see you. Bye-bye.